The exclusionary rule provides that any evidence obtained by the government in violation of the Fourth Amendment guarantee against unreasonable search and seizure is not admissible in a criminal prosecution to prove guilt. The court has stated in numerous cases that the primary purpose of the exclusionary rule is to deter police misconduct. There is some debate among legal scholars as to whether the exclusionary rule is a constitutional or judge-made rule. The reason why this is important is because if the rule is of a constitutional origin, it would be beyond the reach of Congress, even if Congress should want to limit this. While there has actually been some indication from the court that the exclusionary rule is a judge-made rule, it appears as though it is here to stay. Mapp versus Ohio is the case where the court held that the exclusionary rule is an essential part of the Fourth and 14th Amendment. Prior to this ruling, the states could essentially do whatever they wanted. There was an exclusionary rule, however, it only applied to federal cases. However, after the Mapp case, which was decided by the pro-defendant Warren Court, the exclusionary rule applied to evidence obtained unlawfully in both state and federal criminal cases. This was a huge victory for civil libertarians and inmates' rights advocates. Mapp versus Ohio is significant because since 1961, the exclusionary rule has been applied to federal and state criminal prosecutions. Before the Mapp case, the use of the exclusionary rule was left to the discretion of the states. Some used it, whereas others did not. Today, the exclusionary rule may be invoked by a defendant at just about any stage of the criminal justice proceedings. In both federal and state courts, the basic procedure for excluding evidence on a claim of illegal search is seizure. The search or seizure is a pre-trial motion to suppress the evidence. However, even if this fails, the defendant can continue to file motions, and if convicted, a defendant may often file motions to suppress evidence during the appeal process. The defendant must present clear and convincing evidence that a warrant was issued without probable cause or that a search occurred illegally. Interestingly, if a defendant fails to convince a court that his or her rights were violated during the appeal process, the defendant may still invoke the exclusionary rule throughout the habeas corpus proceedings. The fruits of the poisonous tree doctrine is associated with the exclusionary rule. It essentially states that once the primary evidence is shown to have been unlawfully obtained, any secondary evidence, the fruit, would be inadmissible. For example, if police conducted an illegal search of a house where they found a map which shows the location of stolen goods, neither the map nor the stolen merchandise could be used as evidence in a criminal proceeding. The reasoning behind this is that the merchandise would be inadmissible because it is the fruit of a poisonous tree. There are exceptions to the exclusionary rule. One example is known as the good faith exception, which means that evidence obtained by police is admissible in court, even though there was an error or a mistake, so long as the mistake was not committed. So long as the mistake was committed by police, or if the police committed the mistake and the error or mistake was honest and reasonable, then it's okay. The court permits good faith exceptions for errors made by judges, court employees, and police. In their book, the professors Jeffrey Walker and Craig Hemmons point to Maryland versus Garrison as an example where the police erred accidentally, yet evidence was still admitted in a criminal proceeding. In this case, the police obtained a warrant to search a third-floor apartment for drugs and paraphernalia. The police, however, went to the wrong apartment and searched the wrong person. The police still found contraband in Mr. Garrison's apartment, but they were supposed to search Mr. McWebb's apartment. Nevertheless, the U.S. Supreme Court ultimately ruled that Garrison's conviction was valid in light of the information available to the officers when the warrant was sought, and in light of the information available to the officers at the time they acted. Interestingly, the court has recognized an inevitable discovery exception to the exclusionary rule. Essentially, this means that evidence is admissible if the police can prove that they would have inevitably discovered it anyway by lawful means, regardless of their illegal action. So, for example, in a missing persons case, if a city police department forms a search party to look for a body, the body, once it is found, is likely to be introduced as evidence, regardless of whether the sheriff's party came to know of the dead body by either an illegal search or an illegal interrogation, for that matter. Professors Walker and Hemmons point to the 1984 U.S. Supreme Court case Nix versus Williams. In this case, the court ruled that a body which was 2 miles away from one of two search teams would be found regardless of whether or not a suspect had confessed. This is an important case as it helps to establish an exception to the exclusionary rule. Let us suppose that a burglar enters a house illegally and in the course of stealing merchandise comes to find evidence that the homeowner from who he is stealing from is actually a murderer. Supposing the burglar is altruistic, what do you think would happen if the evidence was turned over to the police? Could it be used? The answer is yes. The court has held that the 14th Amendment, the Fourth Amendment's prohibition against unreasonable searches and seizures applies only to the actions of governmental officials. So yes, prosecutors may use evidence obtained illegally by private individuals. In addition to all of these exceptions to the exclusionary rule, it is important to note that the exclusionary rule applies only to criminal proceedings and does not apply to proceedings such as civil or administrative hearings. Illegally obtained evidence may also be admissible in a civil tax proceeding, deportation hearing, as well as an administrative proceeding. So, for example, if a police officer is being investigated by the Internal Affairs Division for violating a departmental rule, illegally obtained evidence can typically be introduced. The exclusionary rule also does not apply in state parole proceedings, at grand jury investigations, and some lower courts have even permitted the trial judge to consider illegally obtained evidence during the sentencing phase of a trial after the defendant has been convicted. It is also important to note that there are searches and seizures which are not fully protected by the Fourth Amendment. For example, if an item is in plain view of an officer, it can typically be seized without a search warrant so long as the item was recognizable as subject to seizure. Plain view has 3 requirements. First, the officer must have an awareness of the item through the sense of sight. Also, the officer must legally be in the place from which the item is seen. And finally, it must be apparent that the item is subject to seizure. So, if, for example, an officer pulls over a driver and sees a marijuana cigarette in the ashtray, this can be seized and used as evidence in a criminal trial. It is also worth pointing out that items found in open fields are not protected by the Fourth Amendment, so they can be seized by an officer without a warrant or probable cause. Also, an area may be an open field despite a locked gate and a no trespassing sign. Having said this, the curtilage surrounding a home is protected under the Constitution. Curtilage, according to Professors Walker and Hemmons, has been defined as the open space situated within a common enclosure and belonging to the dwelling of a house. Curtilage is typically a place that is habitually used for family purposes, including a yard, a garden, and in some cases a nearby field that is used in connection with the dwelling. In short, it is associated with the sanctity of one's home. Generally, the test to determine curtilage occurs whenever a court decides whether or not a person has a reasonable expectation of privacy in a given place. If the answer is yes, then it is part of the curtilage and is protected by the Fourth Amendment. It is important to note that abandoned property is not protected by the Fourth Amendment guarantee against unreasonable seizures and searches. For example, if a car is left in a parking place for so long that it is reasonable to assume that the car has been abandoned, police may seize the car without a warrant. Abandoned property does not belong to anyone because the owner has given it up. Also, property discarded or thrown away in an open field or public place is considered abandoned. For example, drugs discarded by a suspect at an airport restroom when she realizes that she is under surveillance would be considered to be abandoned. Also, Professors Walker and Hemmons point to the U.S. Supreme Court case California versus Greenwood, where here the court held that an officer does not need a warrant to collect garbage left in an area accessible to the public. Usually, police will wait until trash is collected from a suspect's house, or a subject's house, I should say. Let's make that differentiation right now. So it doesn't have to be necessarily a suspect, though it usually is. But nevertheless, they'll wait until the trash is collected from the subject's house, placed into the garbage truck by trash collectors. The minute this happens, the officers will then seize the trash as it has lost its reasonable expectation of privacy, even if obtained inside a curtilage. Finally, Fourth Amendment protections do not apply at immigration borders, particularly at the point of entry. Nevertheless, once an individual makes it inside the border, some protections are afforded. In fact, in recent years, the court has allowed the government to have quite a bit of authority at border crossings. Though Professor Walker and Hemmons do not mention explicitly the case of United States versus Flores, Montano, I should say, this ruling granted police authority to conduct suspicionless inspections of vehicles at the border checkpoints. In fact, in this case, the court even ruled that it was okay for officials to disassemble a tank of a motor vehicle without a warrant. Today, the exclusionary rule is no longer as controversial as it once was. Nevertheless, there is still continuing debate among legal scholars in this area. And as you read through some of the cases in both books, consider areas that you agree with as well as disagree with. Even though certain aspects of the exclusionary rule have proven to be a point of contention among academics, it appears as though the exclusionary rule is here to stay.